4. Now, we have, as I've mentioned, been hearing different perspectives on the Supreme Court ruling last month that the terms woman and sex in the 2010 Equality Act refer to a biological woman and biological sex. The judgment has implications for many organisations. The Equality and Human Rights Commission's interim update says, for example, that in workplaces and services that are open to the public, trans women, those people with gender recognition certificates and those without, should not use women's facilities such as toilets or changing rooms. We have garnered the views of the barrister, trans woman and activist Robin Moyer-White, Helen Joyce from Sex Matters, Sasha Deshmukh from Amnesty International UK and Kate Barker of LGB Alliance. Today I'm joined by Baroness Kishwer Falkner, Chair of the Equality and Human Rights Commission. As the body responsible for enforcing the Equality Act, the EHRC gave evidence in the Supreme Court case. In light of the judgment, the EHRC have now launched a consultation on updating their code of practice. It's up on their website and it runs until the 30th of June. Lady Falkner, welcome to Women's Hour.
Thank you for having me here.
Well, why is an update to the Code of Practice for the Equality Act 2010 needed?
We have put a disclaimer up on our website to say that is now out of date. It was published in 2011, and 14 years on, we were already in process of updating it, and we did a 3-month consultation last year on the updates needed. Because as time goes on, people's social attitudes change. But more than that, cases come to tribunal. Tribunals rule and clarify what they think the Equality Act means. And so over a period of time, the law changes considerably. And it seemed to us not to be helpful to have a completely out of date, or in large parts out of date, code of practice up on our website. So we determined about 2 years ago, it takes quite a while to update everything. We determined 2 years ago to update our code of practice, and that's why we went to consultation and put it out for updating last year. Since then, we've been overtaken by events due to the Supreme Court judgment, and so we've launched the new consultation yesterday, as you've just described, which will be open till the 30th of June.
And I mentioned that date too, but why a consultation and who will take part?
So everyone is invited to take part who's interested in these matters. So it's service providers, associations, users of services. In other words, what we call in legal jargon, duty bearers, as well as the people who use the services. And it will be important that we hear from as many people as possible, because while we have put out our consultation as an accurate understanding of the law, it will be important to hear from people who are actually at the coalface, on the front line, both delivering the services and using the services, so that we can look at areas that perhaps we haven't thought of, or examples that we haven't thought of, and come up with a final practice, which will become law a little bit later in the summer, that will reflect the most contemporary information that we have on how people use and deliver services.
I might get you to move just a tad closer to the mic there, Kishwer, if you don't mind, so
Yes.
I and our listeners can hear you that little bit better. You mentioned there the code of practice that will become law. Will there be a vote in Parliament about it?
There can be. It's a statutory instrument that's laid in Parliament. It's a little bit complex in terms of parliamentary procedure, but there can be a vote in Parliament against it. I think it's called a fatal motion, and that means that the government would be required to withdraw it. But that really is a matter for government. The parliamentary process is no longer owned by the EHRC, it's owned by government. So once we've consulted on the code, rewritten it, and deliver it to government, then it will be in government's hands as to how they manage it and how they deal with it and what methods they use to get it to become the law of the land. In terms of a code, I should emphasize here for your listeners that the Supreme Court judgment and the clarification that it provided is the law of the land, was the law of the land immediately. So all service providers should be getting their own legal advice on interpreting the judgment as of the 16th of April 2025.
Well, that's really interesting. You think each service provider, or anybody that this affects, should be getting their own legal advice?
Absolutely. We've always said that. It is because only providers know their own circumstances. Only they know what they're delivering and how they should deliver it. It's not for us. Ours are general principles that explain the law. But every service provider should be, duty bearer should be getting their own legal advice in that regard.
Because some might think, let's wait for your guidance, the consultation period, and then your guidance, and then see how to implement it. Instead, I think what I'm hearing you saying is it should be implemented immediately using their own personal legal advice.
Well, this is a draft code, and it may well change. The point of a consultation is that we hear from practical examples from people explaining what their circumstances are and how they're dealing with it. The law is done and dusted. The law is not going to change. What may change is how we interpret a given situation where somebody raises to us a practical problem. So it's the practical examples that might change. The law is the law as it stands today.
Messages are coming in, 84844, if you'd like to get in touch. Helen Joyce from the campaign group Sex Matters has asked us to clarify that when we quoted her in the interview with Sasha Deshmukh, a CEO of Amnesty International UK, as saying trans women are men, and that's what the Supreme Court confirmed, she was referring to the Equality Act and not to wider society or any other legislation. Thank you for the messages. If you want to get in touch also through our website is another way. So Kishwer, given this Supreme Court judgment relates to the Equality Act, I'd like to explore for the listeners what settings does the Equality Act apply to?
Well, the Equality Act covers 9 different protected characteristics. So, for example, race or religion or belief, disability, age discrimination. Most of those are relatively settled thanks to our consultation last year. The sections that we're updating, the primary ones are on the understanding of sex, sex meaning a man or a woman, the meaning of how gender reassignment discrimination, the protected characteristic of gender reassignment, and also the protected characteristic of sexual orientation. So those are the ones that we will be updating most principally. There are also some updates on maternity and pregnancy and so on. So it'll cover quite a wide range, but not the whole thing. Mainly these 3 areas that I've described to you.
And the settings that they relate to, you mentioned workplaces, for example, businesses.
Yeah, well, workplace, businesses, service providers, duty bearers, businesses, all of those will be covered to some extent. There will be some other specific updates that will come at later points dealing with greater detail on some of the other areas, other codes of practice that we will be updating. We did a review of how many areas that we needed to cover after the Supreme Court judgments, and there were considerable areas that we needed to cover. But I don't want to give the impression that people should wait until they receive every little different piece of guidance. What they should do, we've dealt with this because this is the biggest area. This covers the most circumstances, and people should be incorporating this, taking due account, getting their legal advice on this and acting on this while we continue to update and provide other areas. And, we will discover as we go through the consultation exercise, we will discover that there are other areas that people want answers to. And we will, of course, respond as quickly, as speedily, and as best we can to those. So I encourage everyone to respond and not to be too concerned about whether they're sticking literally to the parameters of the questions we ask.
Women's Hour question, how does your organisation, the Equality and Human Rights Commission, advice apply to churches and religious communities?
Well, different organisations will have different particular circumstances. And people who are interested in that should write more specifically about their concerns. But they may well be covered by associations, our guidance on associations. I can't tell with each individual case which area of our guidance would cover that. But that is the whole point of doing a consultation, so that people can draw our attention to particular areas that we may have missed, or where there might still be some misunderstanding or confusion or lack of clarity on what they have to do.
Is there any area that's exempt from the Equality Act?
We're probably all covered by the 9 protected characteristics. I don't think there's anyone really who isn't covered by one protected characteristic or the other. So no, if you're talking, I want to be clear, I don't think there's any area exempt by the Equality Act in terms of who we are and the way we live our lives. If you're talking specifically about the exemptions to the meaning of now of the fact that sex means male, female, man and woman, yes, there are specific exemptions. These exemptions are for separate and single sex spaces, of using a proportionate means of achieving a legitimate aim when making the justification for separate and single sex spaces. It covers circumstances where mixed sex services may be necessary, and it covers the potential legal implications of providing only mixed sex services or indeed single sex services. Also, importantly, the circumstances in which it's lawful to exclude participation in competitive sport that a lot of people would be very interested in.
Let's get into some of those examples. There have been some concerns about the ruling itself. I'm sure you've heard that. One, that it could be overturned by the European Court of Human Rights. I'd be curious for your thoughts on that. And also concerns about the immediate interpretation of the ruling, and that perhaps some organisations have jumped the gun by restricting services or activities to biological women. But I think hearing what you're saying this morning is that you would say, yes, get legal guidance and start implementing it. It is reported, for example, this is in this morning's papers, that the Houses of Parliament have not banned trans women from female toilets, that they're waiting on your statutory guidance. Other organisations, like what you mentioned there, have banned trans women already. The FA at all levels of competitive football. Your reaction to those two examples?
Well, the Houses of Parliament are waiting for our guidance. Our guidance is now there. We had considerable demand for answers. We had over 1,000 requests for answers in the first couple of weeks since the Supreme Court judgment. We have moved at haste, but we have not moved at haste at the risk of accuracy. We are confident that this consultation document and the areas that it covers are accurate. And we would urge people to read it carefully, to also read the Supreme Court judgment, also take their own legal advice. But I think organizations have to be aware that they open themselves to legal action if they don't implement the law as determined by the Supreme Court on the 16th of April. So that's what I would say. Read the code of practice that we have put out, and be confident that we think we're pretty accurate in what we're saying. What we want the consultation to do is to give us other practical examples that we may not have thought of as yet. Nobody's disputing what the law of the land is. We know what the law of the land is. It's practical examples and individual circumstances that we're more interested in now.
But you feel, for example, the Houses of Parliament should take a different tack than they have. They say they have not banned trans women from female toilets.
Well, my understanding of the rules that govern the Houses of Parliament, that the law of the land applies to the Houses of Parliament. I leave it to people in higher positions than me to make a determination of what that should be. But it would be quite extraordinary if Parliament didn't find itself covered by the laws of the land.
We have heard from those who feel vindicated and relieved by what they see as a definitive judgment. You talk about it being draft guidance. I just want to read a little of what I read that you said, that this is a complex area of law which bears on the rights of people with the protected characteristics of sex, sexual orientation and gender reassignment. We know there are strongly held views across our society, both about how the law should be interpreted and whether it reflects the right balance between those rights. So if everybody's rights are to be protected, as the Supreme Court confirmed the law intends, service providers and their legal advisors need help to navigate these challenges. How confident are you, also some of the examples I'm throwing out this morning, that the correct balance of rights can be achieved?
It has been a challenge, I have to admit, to balance rights across 9 protected characteristics. For example, sometimes you can take religion and belief and find that comes into some conflict with rights of freedom of expression and so on, free speech. So that is why we exist. We are the impartial regulator of the Equality Acts 2006 and 2010. We exist to help provide that balance, to help adjust the scales so that they're nearly level in everything that we do. And sometimes when we find that they aren't, we take legal action. So we intervene in court cases, as we have done here in the Supreme Court. Sometimes we provide funding for individuals to take action where we will come down particularly on one side or another, where we believe a duty bearer is not doing what they should be doing. Race discrimination, we had a fund on race discrimination for 2 years that we ran to help individuals achieve their rights under race law. So it really depends, but that's what we exist for. We strive to achieve the best balance that we can. But, sometimes that isn't enough for some people. All we can do is balance the law, and we do a pretty good job of it, if I might say, with some pride, as to where we have come to over the last 5 years.
And of course, we're talking about sex and gender reassignment, specifically those protected characteristics in this instance. But do you believe the ruling shifted the balance that we're talking about in favour of biological women?
I think that what I'd like to do is just briefly explain that we felt at EHRC that the balance was in dispute as long ago as 2022. So we published a new code on the single-sex exemptions in April 2022, hoping that duty bearers would take that into account. They didn't quite take it into account as well as we hoped. So in April 2023, we gave advice to the government of the day at the time to say that they needed to consider how to make this work, in that advice, we suggested that biological sex may be one way of defining sex, which might help. And the third thing now, 3 years on, is that we've ended up with a Supreme Court judgment. I wouldn't say that it has shifted the balance. I think I prefer to use the word, it has given clarity to what was always the law. The law was the law. The law hasn't changed. What the statutory interpretation by the Supreme Court has done is giving clarity to the meaning of the word sex that some duty bearers were choosing to ignore. And that's where the clarity has come.
May I ask your thoughts? I just alluded to it briefly, the European Court on Human Rights. Do you think the ruling could be overturned there?
Well, our advice, and we took advice when we wrote to the minister, because we're responsible for human rights and we're a A-rated human rights institution, which is the highest level you can attain. So our advice when we wrote to the government previously was that there would not be a great number of implications. But I can see that some people believe that there will be, particularly under Article 8. That's not for us. That's for the courts to determine. At the moment, we providing this in terms of clarity on the Equality Act, not our human rights functions, although we're very conscious of those human rights functions. But we don't believe they're impacted at this particular stage. We will have to see, these are legal actions. We'll have to see what the causes underpinning, what the arguments underpinning the legal actions are, before I can give you an answer in that regard.
Okay, well, thank you for that. I want to also talk about some of the proposed changes, rules about when a service provider can or cannot ask for someone's birth sex, and also the manner in which it is acceptable to ask. This was picked up in a number of the papers this morning, as you might have seen. Can you elaborate on that for our listeners?
Well, it isn't. Look, first of all, the first thing I would say to all your listeners is that we are a law-abiding but incredibly tolerant country. We work well under the rule of law. We have a long history, going back to the Magna Carta, of obeying the rule of law. There is a social contract between us, between one another, to be tolerant of each other, to allow people to live as full a life as they can, and so on. So in terms of toilet police and people having to carry their birth certificates and things like that, essentially, the key word here that we should all remember in our interactions with each other is trust. We're a society where trust is profoundly important in our interactions. So we have rules and we trust people to follow the rules. Not everybody can carry all their documentation with them. We have a lot of other areas. If you take, for example, a driving license, you're not required in law to always carry a driving license with you. If required, you need to produce it in a certain approach. But the general approach to life is that you should be respectfully, no distress or harassment or discrimination should be caused to trans people. And people should be asked respectfully, carefully, and only when necessary to ascertain whether they perhaps may not be the biological sex of the service they wish to use. And that should be done in a sensitive manner. Remember the words, a proportionate means of achieving a legitimate aim. It must be justifiable. Policies must be justifiable. And they must be done in a careful way because they can engage harassment, direct and indirect discrimination against trans people if they're not done properly and justifiably.
And some might say that puts a lot of pressure on service providers, for example. The example, just to be really explicit, in the headlines in the paper today, were that people might be asked for their birth certificate to prove what sex they are. There is an example that was given in the guidance, a reception taking a trans woman into a side room to ask their birth sex to establish which group counselling service they qualify to join, for example, a single sex or a mixed sex session. It is in the update, I should say. I think what you're telling me, Kishwer, is that there could be a risk of discrimination or harassment if that request was made inappropriately.
Exactly. And the key word is inappropriately or unjustifiably. So yes, you can ask people for further evidence of their biological sex, but I can't imagine it happening with any frequency at all. We're looking at if people are sensible and sensitive and respectful of other people's rights, there should be rare circumstances where it comes to that.
You've updated the description of sexual orientation in the Code of Practice to specify that a person who is attracted to people of the same sex is either a lesbian woman or a gay man, and that will be welcomed by many. But if this change ends up in the final statutory guidance, as we've spoken about, could a lesbian support group still include trans women if they wanted to?
I don't want to get into too much detail on the guidance itself, because it is complex and it'll vary according to different situations. But we have got an entire section on associations, and we give examples there. A lesbian association that wishes to only be set up to accommodate lesbians can do so. A gay association that wishes to set up only to include gay people can do that. And of course, heterosexual associations and mixed sex associations. So it'll vary according to the circumstances. But we have got quite a significant section that clarifies that. And I suggest people read the consultation and also refer to the Supreme Court judgment. The law is set out in the Supreme Court judgment.
Lots of messages coming in. Let me try and get to a couple. Lady Falkner said service providers should obtain their own legal advice. This is all very well for a large company, but what is a small business like mine supposed to do? The type of legal advice being sought is not within the remit of ordinary high street solicitors, and I would need to go to a specialist firm where I will be looking at a bill of at least £1,000.
Our role, I think the questioner here has a very valid point they want to raise. Our role, like other regulators, is to implement the law and to provide guidance on the law. To a large extent, I hope that our guidance will satisfy that person and make them capable of understanding what the law is. So in first instance, read what we say when we publish the final document, read what we say carefully. And, there are advice services that people can use that will be able to shed some light on this. But we also intend to keep our website updated as we go along. And I would suggest that people turn to our website, see what we say, and if they're unclear, in that case, seek specific legal advice. But what I'm not prepared to do is to say that you can interpret what we say any which way you like, and then seek to say that, oh, you followed our advice. Ultimately, each duty bearer has to be responsible for their own interpretation of the law.
One more. I manage a social care company. What are the rules now when delivering same-sex care from 1, the position of a service user who has requested same-sex care, and 2, when deploying trans staff, specifically any male members of staff that identify as women and may or may not have a gender recognition certificate?
I suggest that people go to the specific regulator for social care, and there is a regulator for social care who should be updating their own advice for specific providers who find themselves in specific situations. But again, read our consultation code carefully, because it does set out some of those practical examples and how to deal with them.
Baroness Kishwer Falkner, thank you so much. When can people expect it? I know the consultation is until the 30th of June, but actually having the statutory guidance available?
Well, that is a matter for government. We're aiming to give our finalised code to government by the end of July. And then it's a matter for government as to when they lay it in Parliament and the process they use to make it the law of the land. That's really not for us.
Baroness Kishwer Falkner is Chair of the Equality and Human Rights Commission. My thanks to you for coming on. And if you want to listen back to any of our previous interviews with barrister and trans woman Robin Moyer-White, Sex Matters Helen Joyce, Amnesty International UK Sasha Dishmuk, or the LBG Alliance's Kate Barker, go to BBC Sounds. They're the episodes from the 12th, 14th, 16th and 19th of May. Again, if you want to get in touch with the programme, 84844 is one way to do it, at BBC Women's Hour.